You have the right to remain silent.
But we'd prefer if you didn't.
Spinning the law, spinning the law.
This is Malzberg's
Spinning the law.
Spinning the Law
Spinning the law, spinning the law.
with attorney Kendall Coffey.
All right, ladies and gentlemen, here we are, Spinning the Law, and we are joined. I am very happy to say he made accommodations for us as he does every time he appears, but today is Wednesday, and we squeezed in another edition with Kendall Coffey. Hey, Kendall, how are you, sir?
Doing great, Steve. Doing great.
Well, all right. Well, here we go with in the midst of everything else that's going on. One of the bad things about this Egypt thing taking place today is that they cut off all the coverage, at least most of the networks of the trial, and I didn't get to see court TV, so maybe you know more than I do. But I know what happened today was, and I'm a little confused. Well, not confused, but let's focus on today. And by the way, the prosecution, Kendall, said that they will probably rest no later than Friday morning, which means they could rest this afternoon or Friday morning. Do you believe that they'll be calling Trayvon's mother as their last witness before they rest?
I absolutely do. Not a witness that normally you would want to have to rely on, but not a lot of things have gone well for the prosecution in this case. And so, one of the things they're hoping is, look, there's a young man who's dead, he was unarmed. His mother can undoubtedly speak in a powerful way that may reach some of the mothers on the jury. Is that enough to convict? Is the jury going to accept her testimony that it was Trayvon's voice screaming for help? Hard to say, because Zimmerman's got family members who are going to say exactly the opposite. But in the condition the prosecution's case is in, they're going to have to rely on the mother of an alleged victim, even though, she doesn't have any knowledge of what actually happened that night, except for her expected testimony about the voice on the 911 tape.
Let me ask you a question, because lots of times I play lawyer in my own head. Could Mark O'Mara, in a very pleasant way, very pleasant manner, as sympathetic and as empathetic as possible, say, you heard Ms. Gentile say that your son described George Zimmerman as, in a derogatory fashion. I believe the term was, crazy-ass cracker. Do you believe that your son said that? Now, if she says no, it impugns the integrity of the testimony of the witness. If she says yes, then, and again, you got to be careful how the jury, you don't want to be seen badgering the woman, but it does bring up, I think it's a win-win. Either she says no, he would never say that, and in which case, so she's implying the witness lied, and if she says yes, she's got to explain away crazy-ass cracker.
Well, I in some situations I would agree with you, but look, it's a question that's going to embarrass a woman who's lost her teenage son. 5 mothers on the jury. And perhaps most importantly, Steve, I think the defense thinks they're ahead. I think if we're analogizing this to a football game, I think they've got at least a touchdown or more ahead in their minds. Why would they take a chance on perhaps offending the jury, prompting tears on the stand, or maybe even an answer that no one can expect?
Right,
so
right.
If they were, well behind, and they thought they had to be aggressive or do something with the mother of somebody whose life is lost, maybe. But I think O'Mara's gonna be cautious, as you say, empathetic and sensitive, and do a limited cross on the mother. Just basically bring out the obvious, that she'd never heard his voice in a situation anything like this before, and that the most obvious of all is she's the mother, and she wants to see something done about the loss of her son's life.
All right, see, that's why you're Kendall Coffey and I'm not. All right, so now...
But you're a great radio host.
Well, I appreciate that. I appreciate that. And, folks, I just want to let you know what kind of guy Kendall is. Kendall, one of the most well-respected attorneys in all of the world, whenever I book him and I reach out to him and say, can you do it, he always writes me back, thank you for including me. And I'm like, I want to write back, you don't get it. No. Thank you for making time for us. But that's the kind of man Kendall Coffey is. Just want people to know that. You certainly didn't ask me to say that. Anyway, so let me ask you about what happened today. 2 things. One, the judge decided that that in a sense the past of George Zimmerman could be admitted. He took he applied to be on the police force in a jurisdiction in Virginia, so they let the guy who received his application from the force testify to that fact. She also let in the fact that he took a criminology course a few years ago and let his criminology professor come in to discuss what he learned there. The implication of that being, I assume, he's a rogue wannabe cop, and he was fully aware of the stand your ground laws, et cetera, et cetera. That aside for a second, does that now also open the door for the defense to certainly request and maybe, and you tell me if it could be denied after she let this in, Trayvon Martin's past with regard to fighting and school suspensions and anything else?
I think there's a little risk of that. On the other hand, I think the biggest risk to the prosecution in terms of opening the door is really with Trayvon Martin's mother, because it's going to be hard for her not to want to talk about her son and what a wonderful young man he was. But if she goes very far into his life, it presents any kind of a bio of Trayvon Martin, then I really think the danger is real that the door opens, because the prosecution has basically said, we put into issue the past of Trayvon Martin. And if that happens, you can bet the defense is ready. If that door is open even a little bit, they're ready to come bursting in with a lot of things that the defense has wanted to talk about.
Right, but not to the mother. They won't bring it up to the mother, right? Because that would do the same effect. They bring that up in their defense case.
In their own case,
yeah.
They'd say that the direct examination of the mother, some of the things she said,
right,
allow them in their case, because now the door has been opened. And that's something to watch very closely when she takes a stand. And
you say very little threat. You mean so that door was not opened by the judge's decision with regard to the police application and the course on criminology?
I don't think so. That was really just the knowledge, the skill set, the expertise, maybe impeachment of Zimmerman. It wasn't really saying that George Zimmerman was a violent guy, for example, such as bringing in his prior arrest or bringing in his whatever the domestic violence issue is. Those are the things that would have assuredly opened the door to Trayvon Martin's past. I'm not sure if that door has quite been opened yet.
We're talking to Kendall Coffey here on the Steve Malzberg Show. Explain to me about DNA. I only got to see the DNA expert to say how there was no DNA from Trayvon Martin found on the gun at all, and there was let me get this straight in my head. There was no DNA from, I think, Zimmerman's. There was no Trayvon Martin DNA on Zimmerman, blood DNA or DNA on Zimmerman, if I'm not mistaken. Now, I didn't see the cross-examination. I could only assume it went on. Maybe did you see it?
Didn't catch.
Okay.
No.
What is it? And we've heard this. At least I heard it brought up by probably analysts such as you're doing at NBC, talking about the case, saying that rain could wash away DNA. Now, is that something you're familiar with, and is that probably one of the things that O'Mara will or had or might bring up in cross-examination?
Absolutely, and he's already set the stage for that, because there have been a number of references throughout the first week of testimony about the weather conditions and about rain and about blood that might have been on the sidewalk washing away. So I think he's set the stage pretty well to establish that it really doesn't mean much anything if there's no fingerprints of Trayvon Martin on the gun, if there's no DNA on the gun, because the prosecution's trying to make the point that Zimmerman asserted that Martin grabbed the gun. There's no evidence of that, but I think by the time we're through with this trial, the jury's not going to make a lot on that, because there are just so many other explanations, including weather, including just sometimes the fact that fingerprints don't readily attach to the surface. There's just so many conditions that affect that I don't think the jury's going to put a lot of weight on the fact that there's no actual proof that Martin grabbed the gun. And the DNA expert would, in all likelihood, will acknowledge that, right? As far as you know, because if that's the fact, then he has to acknowledge that. When they're crossed effectively, as I think we can expect here, they will acknowledge all the limitations and all the reasons why there might not be any sample that are a matter of conditions.
What you say that you believe the defense believes that they are on the whatever yard line you said that they're way ahead. What do you believe at this point? In your assessment, if you were a jurist, you haven't seen all the testimony, but from what you've seen, where do you think they are?
I've seen a lot of the testimony, and I've obviously been following the case closely. I think the defense is ahead. I don't exclude the possibility. I've seen prosecutors put it all together on closing argument, and then all of a sudden it hangs together. But if this trial ended tomorrow and nothing else was heard by the jury, I certainly don't. I think they would find a reasonable doubt as to second-degree murder, manslaughter, which is a lesser-included offense, which the jury could find, and the judge will likely instruct them on, may be a possibility. But right now, I think the prosecution is having some real problems, and one of the results of the current, I think, status of the case is I do not expect the defense to call George Zimmerman. Normally, you have to if it's a self-defense case, but I think through the prosecution witnesses, the defense has brought out enough to establish a claim of self-defense so that I don't think they're going to put George Zimmerman on the stand.
Yeah, and I think that we could also count from what we've seen in the cross-examination, the presentation of the defense, especially from Mark O'Mara, that he will tie it all together as well in his closing statements. Would you agree?
Yeah, and he's got a lot of things he can raise. One thing you've seen throughout the trial, and I think the defense has done a good job, I think the prosecutors have done a good job with what they've got, is the difference it makes in a state like Florida where you have depositions in a state criminal case. We're one of maybe 4 or 5 states in the country that actually allows defense lawyers to depose prosecution witnesses. A huge procedural advantage. It makes a difference in a lot of cases in the state of Florida, and you're seeing that O'Mara and West have made the most of that procedural advantages because time and time again, when they cross-examine the prosecution witnesses, they know what the prosecution witnesses are going to say. They've taken their deposition, and they bring out the points that are positive to them. And a lot of times, it seems, Steve, like, gosh, by the time the witness is done, turn into a defense witness.
Absolutely.
And the depositions in Florida are a reason that becomes more doable here than in most jurisdictions.
Time and time again, witness after witness. I mean, he's done a masterful job, I guess aided and abetted, if you will, by what you just alluded to. 2 more brief things. One, in the interview, the Sean Hannity interview that they aired in court and then gave no follow-up to. It's just they aired it and it just hung there and that was it. Zimmerman, from what I remember, says to Hannity he was not aware of stand your ground laws in Florida, yet he apparently learned it in his course. That kind of inconsistency, I mean, is that something that they're going to, if they drive it home, is that something the jury's going to say, uh-oh, this is huge? I mean, does that really make a difference considering the fact that the police and witness after witness said he's been consistent and any inconsistencies that he gave were just minor and consistent with any witness or anyone who was in such a situation in the past?
Well, a couple points. I think it's always a mistake to put a criminal defendant on up for an interview. I mean, unless of course it were your show. But apart from that,
yeah.
it's just bad because they say things that don't sound great. And
right.
I thought some of Zimmerman's comments, especially the ones where he basically said, "We got to come back to the fact a young man unarmed is dead." And when Zimmerman is asked about any regrets about getting out of the vehicle that night, he basically says no. So there's a lack of remorse.
Yeah, like it was God's will or something to
that
effect. Yeah,
those were not wise.
Yeah.
Those were not sensitive remarks, and they're not going to play well. I mean, they don't amount to any kind of confession of guilt, but they're not sympathetic. What I don't think the prosecution will get anything out of is that discrepancy between taking stand your ground course a few years ago and the comment he made. And the reason is, I mean, jurors have a lot of common sense. Everybody thinks back, okay, when I took courses, was it college, was it high school, what the heck did I remember 2 years afterwards? And the answer, honestly, is not much.
Yeah.
So I think when the jurors search their own experience about that, they're not going to be too upset that perhaps Zimmerman didn't remember a course he took a few years earlier.
And one more. Is there any evidence that you could think of that the prosecution scored with that the defense hasn't countered by at least bringing in reasonable doubt, if not, in fact, swaying it the other way?
The prosecution has been able to make almost no points without a meaningful defense response. The best points for the prosecution came early when, frankly, they presented the photographs of a young man who was killed.
Right.
So they've got that. They'll close with the impact of the mother's testimony. But this has been a case for the prosecution that's been tough. And among the things that just jumped out at me was having Chris Serino presented as a lead investigator so damage the prosecution's case. Say ultimately that he thought that Zimmerman, who was claiming self-defense, was being truthful.
Yeah, but then he had, now even though he had to take that, or the jury was told to disregard that the next day, that's in, right?
That is in. It will not be forgotten. And frankly, jurors will remember the statement. They may not even remember that the judge told them to disregard it. So I think the fact that a police witness, who should have been kind of like the lead advocate for the prosecution's case, so significantly undermined it, I just have a lot of trouble seeing a conviction here. But juries are hard to figure, and I'm telling you, we've all watched cases where the prosecution gets down to closing, they put it together, and all of a sudden there's a real connection that the jury sees, and surprising verdicts can happen. So I'm not going to rule that out.
I hear you.
But right now, as we await the holiday, I think the defense is feeling pretty good about things.
Yeah, no, absolutely. Kendall, thank you so much. Have a great 4th of July weekend, and hopefully we could, maybe the defense will rest by next week. Maybe by this time next Thursday they'll be in jury deliberations. Who knows?